Good morning, good afternoon, or good evening. Uh, our esteemed guests, my dear students, and other attendees. It is my utmost pleasure to invite you to tonight's webinar with Professor Kevin Jon Heller. Before I talk about the topic on which Professor Heller is going to speak on, let me just say a very few words about Professor Heller. Kevin Jon Heller is a professor of international law and security at the University of Copenhagen's Center for Military Studies, and also a professor of law at the Australian National University. Kevin's books include the Nuremberg Military Tribunals and the Origins of International Criminal Law, published by Oxford University Press, The Hidden Histories of War Crimes Trials, also by Oxford University Press, and the Oxford Handbook of International Criminal Law. He currently serves as the Special Advisor on International Criminal Law Discourse to the Prosecutor of the ICC. Now, if I briefly say a few things about this evening's topic, I think Kevin's topic is very lively. And as I was chatting with him just before we came live, maybe he happens to be, in a way, a minority among the mainstream scholars. But that doesn't mean that his scholarship in this issue is in any way something which anyone can brush aside easily as a sort of scholarship without rigor. It's a very thorough paper that he has written. I would say a seminal paper. I would not be surprised if his paper elicits criticisms and accolades from both sides of the debate in coming days. This talk is basically, as I understand, is based on one of his European Journal of International Law articles published very recently. Now, the topic that he would talk on, the unilateral humanitarian intervention, is a very contested issue. To me, there are three very crucial questions. One is UHI or unilateral humanitarian intervention legal? Secondly, what is the motivation for this UHI? And thirdly, what about its consequences? In Kevin's paper, I think he has covered all these issues very thoroughly, very rigorously, and in my view, very persuasively. Even those who somehow could perhaps have sought justifications for their unilateral humanitarian interventions, often they haven't done so, or they have used these UHI as one of the justifications for their aggressive acts. Maybe at times they have said that they were acting to protect their own nationals abroad, or they were acting in self-defense, whether or not justifiably so. Or in some cases, they have cited other reasons rather than simply saying that their action was driven by humanitarian considerations. So I think he has made a very compelling case that unilateral humanitarian intervention can hardly be justifiable. And we all know how much havoc it has caused in certain parts of the world, even in our recent memory. So I eagerly await to see what he says tonight. And also, of course, I look forward to your questions, dear audience. Thank you all. Professor Heller, the floor is yours.
Thank you, Rizwan. Very kind introduction. I appreciate the invite. It's always I think particularly enjoyable and gratifying to speak to audiences that are not just the typical audiences here in Northern Europe, as I'm sitting in Denmark right now. I don't want to talk for too long. It's a long article, and I just kind of want to give you kind of a skeletal sense of the highlights of my argument. And then I look forward to your thoughts and your questions and comments and criticisms and all of that. A little bit of context before we get into the article itself. I I had an exchange on the pages of Opinio Juris, my blog, with my old friend Harold Koh. You probably know who Harold Koh is. He is not only the former dean of Yale Law School, but he was Hillary Clinton's legal advisor when she was Secretary of State. And he called me in one of his blog posts at Opinio Juris, quote, "objectively pro-slaughter." And he called me that because I said that it would be illegal to engage in unilateral humanitarian intervention in Syria. And that exchange really kind of got me thinking about what ultimately became the article that I'm talking about tonight. And it was that I am in a somewhat of a minority position in kind of Western scholarship in terms of my antipathy toward unilateral humanitarian intervention, and certainly in my belief that it's actually the crime of aggression. But what was so striking when I read the literature, and frankly, the literature that either disagreed with me or agreed with me, was just kind of how sloppy it was, how very not careful it was about particular instances that were alleged to be humanitarian. And what I really wanted to do was I wanted to do something that was very systematic and very thorough. And yes, I had an argument, and yes, I came into it with a particular belief, but something that would really try to be fair and careful to all of the arguments pro and con about unilateral humanitarian intervention. And I don't know whether I have succeeded. I think that's up to the people who have read the article to decide. But let me spend a little bit of time, and again, not too much time, talking about the article itself, just to give you a sense of what I argue. So scholars who defend unilateral humanitarian intervention, and I will probably just refer to it as UHI because unilateral humanitarian intervention is a mouthful to say over and over again. Scholars who support UHI generally make two interrelated claims. And the first one is a kind of a strictly positivist one, that unilateral intervention is actually internationally lawful if it is genuinely intended to end mass atrocity. The second argument then is more normative or ethical, that genuinely humanitarian unilateral intervention should be lawful because in the right circumstances, it can be an effective mechanism for protecting civilians from harm. And so what I do in the article is essentially challenge both of those arguments. And so let me start with whether UHI qualifies as a criminal act of aggression. And there's two interrelated issues here. The first is whether UHI involves a use of force that is unlawful, a use of force that violates Article 2.4 of the UN Charter, i.e. the prohibition of the use of force. That's the first issue. And then, and we'll come back to this when we look at the crime of aggression, whether that criminal act of aggression constitutes a, quote, manifest violation of the UN Charter for purposes of the Rome Statute. So the crime is more difficult to prove than just the unlawfulness of the aggressive act itself. So I want to run through both of those. The first question is whether UHI is actually a prohibited use of force. There's no question that it's actually a use of force. The whole idea behind unilateral humanitarian intervention is that you're actually using force on the territory of another state precisely to end some kind of humanitarian crisis in that state. We're not talking about a state using force on its own territory. We're talking about it intervening in the internal politics of another state because of humanitarian concerns. So there's no question that if you just look at Article 2.4, it is a use of force. You will see, if you really dive into the literature, that there are some scholars who try to find a way around UHI violating Article 2.4. And really the classic example of this are a couple of American scholars writing 40 or 50 years ago, Michael Reisman and Myers McDougall, who say, well, using force on the territory of another state to protect civilians, that's not really seeking a territorial change in the territorial state. It doesn't challenge the political independence of the state. It's not inconsistent with the purposes of the United Nations, because what is the purpose of the United Nations if not to protect human rights? So they try to make a textual argument that Article 2.4 isn't even violated. That doesn't really work, Because if you look at the drafting history of Article 2.4, what you see is that it is intended to be an all-encompassing prohibition. It is supposed to be a flat ban on the use of force unless, in fact, it is with Security Council authorization or pursuant to the right of self-defense. Now, obviously, UHI isn't authorized by the Security Council. The very definition of unilateral humanitarian intervention is that it's not. We're not talking about a situation in which the Security Council says to states, you can use force. So then the only real question is, can it be plausibly described as self-defense? And it can't. If you look at Article 51 of the UN Charter, it has to be an armed attack on the state that is using defensive force. In other words, state X can only use force against state Y if state Y has launched an armed attack against state X. And that's not what we're talking about here. We're talking about state X intervening on the territory of state Y because state Y is harming its own civilians. They're defending the civilians. They're not defending their own state against an armed attack. So again, merely textually, there is no plausible argument that UHI is self-defense. So at least at first blush, this is a violation of Article 2.4. It is an unlawful use of force. Now, that doesn't mean that there aren't other ways in which a UHI could be considered lawful. And I run through a whole bunch of them. I'm not going to go into all of them. Really, the most important argument is that regardless of what Article 2.4 might say, there is a new kind of customary rule of international law, or a rule of customary international law, that allows for unilateral humanitarian intervention as an exception to the prohibition of the use of force. This is an old argument. It dates all the way back to the mid-1960s, but it really wasn't until Kosovo that this really picked up speed among scholars. But a number of scholars say there is now a customary exception to the prohibition of the use of force for unilateral humanitarian intervention. And again, what I really try to do in my article is to be very careful in my response to that claim, because I don't think the claim is successful. I don't even think the claim comes close to being successful. So how do we think about whether there's a customary exception to the prohibition of the use of force here? The first thing that we have to say is that it's not enough that an intervention has humanitarian effects. I'll come back to that. I actually think there's not very many that have had humanitarian effects, but just because in the result, it might have made civilians' lives better, doesn't mean that it's the kind of humanitarian intervention that would help establish a customary rule of international law. We have to be, and this is what I really want to impress upon you, we have to be very careful about how we categorize humanitarian interventions, or how we categorize interventions as being humanitarian. So there are three types of unilateral interventions that don't count toward a customary exception, and we have to rule out. And the first is where the intervening state doesn't actually argue that their intervention is justified on humanitarian grounds. In other words, where they invoke a more traditional legal rationale, such as self-defense or the consent of the territorial state. The ICJ has made very clear in the Nicaragua case that it's not going to, or that it will only take into account in terms of determining custom, the actual claimed legal justification for a use of force that a state makes. So if they invoke a different legal justification, that's the relevant legal justification. And we can't kind of after the fact say, oh, in fact, this is a humanitarian intervention. That's the first situation. The second situation is where the intervening state doesn't offer any kind of formal legal rationale for its actions. We all know that there are situations in which one state will use force against another state and simply not justify it. Now, this tends to be the more powerful states that can kind of get away with that kind of action. I'm thinking like the US in Syria in some respects. But even if that kind of intervention has positive humanitarian effects, that doesn't mean that it counts toward the legality of unilateral humanitarian intervention. In the Nicaragua case, the ICJ said very clearly that we cannot, quote, ascribe to states legal views which they do not themselves advance when we're determining whether practice helps establish an exception to a customary rule. So if they don't tell us why they're intervening, that intervention doesn't have any legal meaning in terms of the formation of custom. And then the final and probably the most complicated situation is where the intervening state does mention unilateral humanitarian intervention as a rationale, but it also invokes another rationale. So it says, oh, we're motivated by humanitarian concerns, and there's consent, and there's self-defense, and some other legal justification. Can that kind of intervention count toward unilateral humanitarian intervention's legality? Not really, because again, we don't know in that kind of situation whether the state is actually trying to create the customary exception for UHI. And even more problematically, because so much of the arguments in terms of custom rely on the silence or the acquiescence of other states in the face of a ostensibly humanitarian intervention, we don't know what the silence means. Now, we could have a long discussion about when, in general, you can rely on silence to help establish the pinio juris in favor of a customary exception. But we certainly can't rely on silence in that way if the state that is intervening doesn't make specifically clear why it's intervening. That silence could mean approval of consent. It could mean approval of the self-defense argument. It could mean approval of humanitarian intervention, but we don't know unless the state makes clear that its only justification for intervention is in fact humanitarian. So with those rules in mind, in the article, I then go very kind of systematically through essentially all of the uses of force that scholars have at one point in time identified as supporting a customary exception for unilateral humanitarian intervention. And I'm not going to bore you by going through all of them. Let me just kind of give you a sense of why scholars are sloppy in how they categorize the importance of these interventions. So think about India's invasion of East Pakistan in 1971, often mentioned as an early example in the second half of the 20th century of unilateral humanitarian intervention. Well, India didn't claim unilateral humanitarian intervention. It justified its actions by reference to self-defense, self-defense against military aggression in the form of armed attacks by the Pakistani military, and what they called refugee aggression in the form of millions of Bengalis fleeing East Pakistan's repression into Indian territory. So India didn't claim UHI, and in addition, the UN General Assembly voted overwhelmingly, 104-11, to demand that India withdraw its forces. So it's very hard to see India's invasion of East Pakistan as supporting UHI. Another very common one, Tanzania's intervention in Uganda in 1978. You saw a little bit of reference to humanitarian concerns from the Tanzanian government, but its specific legal claim was to be acting in self-defense, a response to Uganda's occupation and purported annexation of Tanzanian territory. And so even after the Organization of African Unity condemned the intervention as a violation of Uganda's sovereignty, Tanzania still didn't invoke UHI as a legal justification for its use of force. Another one, this one's really common in the pro-UHI camp, Vietnam's invasion of democratic Kampuchea, now Cambodia, in 1978. This is an important one because it's one of the very, very few examples in which an invasion probably did genuinely have positive humanitarian ends. Getting rid of the Khmer Rouge was certainly, on balance, a positive thing. But once again, we don't see Vietnam invoking humanitarian concerns. It claimed to be arguing in self-defense, or acting in self-defense because of cross-border attacks. And it claimed to be acting at the request of the legitimate government, which was then the United Front for the Salvation of Kampuchea. And even despite that, the General Assembly still denounced the invasion and demanded that Vietnam withdraw its forces. So however positive the effects might have been of that invasion, it was certainly not a precedent for unilateral humanitarian intervention. Couple more. If you look at like the no-fly zones in northern Iraq in the first Iraq war, seemed very much motivated at protecting Kurds and Shias from the Iraqi government. But if you look at what the legal arguments that were made were not particularly humanitarian. The USA completely relied on implicit authorization by the UN Security Council. France never clearly articulated a legal position, though it also kind of hinted at Security Council authorization. And although the UK eventually did explicitly argue the legality of unilateral humanitarian intervention, it did so only after it cited the Security Council. And then later, it invoked self-defense in the context of its specific attacks on Iraqi planes and missile sites. Kosovo, last one I'll mention right now. This is probably the most commonly invoked precedent for the legality of UHI. But it actually, again, when you really dig into it and you look carefully at what states did, it actually provides UHI with little support, because only the United Kingdom and Belgium ever formally asserted the legality of unilateral humanitarian intervention. And in fact, Belgium, which did insist on its legality in Kosovo, later insisted that Kosovo shouldn't be seen as a precedent for UHI. They didn't want what they said was a return to the jungle by kind of having open season on this kind of invasion. And Germany and France and the USA all agreed that this should not be a precedent for unilateral humanitarian intervention. And that was just kind of the Western states. And then if you look, as we should, at states in the global South, whose voices we tend to completely ignore in my part of the world, NATO's intervention in Kosovo was explicitly condemned as unlawful by the G77 twice, by the non-aligned movement, and by the Islamic Conference, 133 states in all. So in Kosovo, you have 2 states that claim unilateral humanitarian intervention is lawful, and 133 states that say, no, it actually wasn't. So very difficult to balance those two and say, oh yeah, unilateral humanitarian intervention is now lawful under customary international law. So really what we see are 2 things. We see states trying to avoid clearly and exclusively relying on a clear state consensus on its illegality. And he says, like many other scholars, that there isn't enough state consensus on the illegality of humanitarian intervention to make it a manifest violation. But that's very difficult to defend because, as I've just said, there are only 3 states in the world that at any time have ever specifically said that unilateral humanitarian intervention is legal: the UK, Belgium, and Denmark, whereas the entire G77 non-aligned movement and Islamic Conference have consistently insisted that it is unlawful. I would submit that if 3 states think something is legal and 133 states at a minimum think it is illegal, that is not a gray area or a borderline case about whether the use of force is unlawful. It seems completely clear to me that that is precisely the kind of manifestly unlawful or manifest violation of the UN Charter that is deemed criminal by the Rome Statute's definition of aggression. So it is a violation of the prohibition of the use of force, and it is a manifest violation of the prohibition on the use of force. And that means that it is at least prima facie criminal under the Rome Statute to be involved as a high-level leader. I don't have time to get into all of the elements of the individual criminal responsibility, but it's just a classic example of something that should be considered criminal. And I don't think that this is a particularly radical view, even if many people disagree with it. There was a reason why some states, particularly the United States, during the drafting of the aggression amendments at the ICC, why they tried so hard to specifically exclude humanitarian intervention from the crime of aggression. The USA tried on at least 3 different occasions to introduce language, whether into the actual definition itself or through, quote, an understanding of the aggression amendments that would have ruled out considering humanitarian intervention criminal. And every time the US tried to do this, the proposals were defeated by extremely large majorities of the states that were involved in the drafting. So I think states were fully aware that, in fact, unilateral humanitarian intervention could be considered the crime of aggression. So that's kind of the positivist part. And I took a little bit more time than I was expecting on that. So I want to move more quickly through the normative question, which is, okay, if we assume it's criminal, is that a good thing or is it a bad thing? Again, lots of scholars say it's not only lawful, but it's a good thing, that we want humanitarian intervention to be lawful because it is sometimes, in the extreme case, a necessary response to atrocity. here, there's really kind of two assumptions. The first is that, in fact, states do engage in interventions that are genuinely humanitarian or are genuinely motivated for humanitarian concerns. And the second assumption is that sometimes unilateral humanitarian intervention actually works, that it will, in fact, not just be well-intentioned, but it will improve the situation on the ground. Now, these are empirical questions, obviously, and I don't have time to get deeply into them, but I question both of them. I question how often humanitarian intervention is actually humanitarian, and I question whether most interventions that are claimed to be humanitarian actually have humanitarian effects. And just like I did in terms of the creation of custom, in the article, I go very systematically through all of the various situations. And what you see is even the interventions that look kind of humanitarian, like the Vietnam's invasion of democratic Kampuchea, of Cambodia, that they don't tend to be motivated by humanitarian concerns, that they're trying to reassert their power or they're trying to end attacks on their own people. They don't tend to be motivated by genuinely humanitarian concerns. And if they don't, it's kind of hard to classify them as genuinely humanitarian intervention. So one example would be Rwanda. It is probably good that France intervened in Rwanda in 1994. It claimed to be helping end the genocide, the Hutu genocide of the Tutsis for humanitarian reasons. But actually, if you look at scholars who know far more about France and Rwanda than I do, they don't buy France's claims to be acting in a humanitarian way. They claim that what they were really concerned about was making sure that Rwanda didn't move into the Anglo-American sphere of influence and out of kind of the Francophone sphere of influence. And these scholars point out that France talks a good game about humanitarian concerns, but basically they didn't actually intervene in Rwanda until the worst of the genocide was over. If they had really been concerned about it, they would have intervened much, much earlier on. And you can say something very similar about the interventions in Syria. A lot of people have claimed that, like the US destruction of airfields and chemical weapons plants with the help of the UK and France, that this was really about trying to do the right thing for the Syrian people. Well, if you look at what, like, say, the US actually said, it's quite clear that they were not motivated by humanitarian concerns. Again and again, Donald Trump, the French president, the prime minister of the UK, they all emphasized the need to avoid the spread of chemical weapons. Why were they concerned about chemical weapons? Because chemical weapons could be used against them, not just to kill Syrian civilians. It could be used to kill American military personnel or Americans living abroad, etc. They were trying to deal with the one type of weapon that affected them, not trying to protect Syrian civilians who, unfortunately, if you're dead, you're dead. You don't care whether you were killed by a chemical weapon or by a conventional weapon. And so even like the UK, which did claim to be acting in a humanitarian fashion, we should be very skeptical of those claims. As my friend Marko Milanovic has noted, if the UK had truly been motivated by humanitarian concerns, it would have supported a far more significant intervention. Instead, it chose to support a response that basically stood no chance of significantly improving the humanitarian situation on the ground. Again, it was a limited intervention to protect against chemical weapons. It wasn't really about improving the lives of ordinary civilians. So then the final issue, and I'll end with this, is just, does it work? Do we look at the historical record and see examples of interventions that really do improve the humanitarian situation on the ground? It's not impossible to find that. As I said, Vietnam's invasion of Cambodia probably did have humanitarian effects. We could also mention East Timor, where international intervention helped bring stability to the area and made possible Timorese independence from Indonesia. But that, of course, wasn't unilateral. That was actually Security Council authorized. And against those two examples, we can then find a whole bunch of both Security Council authorized and unilateral interventions that made the situation on the ground far, far worse. We can think about international intervention in Somalia, which might have had short-term positive effects, but has basically destroyed the Somali government since. There's been endless violence, endless conflict, routine mass starvation among Somalis, didn't make the situation better. And if we think then of Libya, NATO's humanitarian intervention in Libya, things have been even worse. I don't need to tell you too much about the state of Libya since the NATO intervention. Suffice it to say, it is a humanitarian disaster. So the bottom line is we should be very skeptical of claims in defense of unilateral humanitarian intervention. Again, I think that the legal case against it is fairly overwhelming. I think it's both a violation of the prohibition of the use of force, Article 2.4, and the crime of aggression. But I also think we should be very skeptical of what seems like a very seductive normative argument that, okay, maybe it's illegal, but if it's a good thing, shouldn't we kind of turn the other cheek? Shouldn't we look the other way? Well, we should be skeptical of state claims to be acting for humanitarian reasons, because normally they fall apart upon actual examination. And we should be even more skeptical that humanitarian intervention works. For every example of a successful humanitarian intervention, even if it wasn't motivated necessarily by humanitarian concerns, we can find 5 to 10 examples of interventions that have made the situation on the ground vastly, vastly worse. So given that my answer to both of those questions is the same, I can't see any real plausible reason to consider unilateral humanitarian intervention anything but criminal. And I'll end with that.
Thank you, Professor Heller, for an excellent presentation. We have got several questions, so let me read them to you one by one. The first question asks you that, well, if the unilateral humanitarian interventions were illegal, what about the question of justice? What about the violation of use of force? And what about the crime of aggression? Could those states or the masterminds be criminally or responsible under civil laws of international law?
Well, I mean, so there's a couple of questions here. There's the kind of the formal question and the pragmatic question. I mean, the formal question is the one that I've been addressing, which is I do in fact think that these things violate the Rome Statute's definition of aggression. And so anyone who is in a position, quoting the language from the statute, to control or direct the political or military machinery of the state, who participates in the planning, formulation, the planning, execution, the four ways that one can participate in the crime of aggression, they are guilty of aggression. If you're a high-ranking leader and you send your forces off into another country, even ostensibly for humanitarian concerns, that is the crime of aggression, in my view. Now, does that mean that there's going to be actual prosecutions of these people? Well, I mean, it's a much longer discussion about whether the crime of aggression really works at all for any kind of intervention. But I'm certainly not saying that if the extremely unlikely scenario happened, if in fact a state really did unilaterally intervene for the purest of motives, and despite all the evidence to the contrary, actually pulled off a successful humanitarian intervention that really did make the lives of civilians in the invaded country better. In the face of that perfect intervention, I am quite sure that the prosecutor would decline to prosecute those government officials. May technically be criminal, but the prosecutor has discretion. She previously can make informed decisions about whether or not an act that technically violates the Rome Statute is the kind of thing that the court should be spending its precious resources on. And so if you had a genuinely positive humanitarian intervention, I am quite sure that that would not end up in a prosecution. But we still need to establish the criminality of it because of all the other ones, the ones where humanitarian claims are being used as a pretext to control resources or to assert influence or to punish a leader that a powerful Western country dislikes. And let's be clear about this. We can go back 40 or 50 years and see states in the global south engaging in interventions in other states in the global south. But these days, the overwhelming use of force comes from the global north against the global south. So when we are leaving the legality of unilateral humanitarian intervention open, what we're really saying is to the US's and the UK's and the France's and the Russia's of the world, you can use force on the territory of states in the global south. And I think we should be skeptical of that as much as we possibly can.
Thank you. The next question asks that what is then the role of the doctrine of responsibility to protect? When can it be invoked? How can it be invoked?
Yeah. No, it's a very good question, and it's a very important distinction to understand. Unilateral humanitarian intervention is very separate from R2P, from the responsibility to protect. If you look at the founding document of the responsibility to protect, the UN working group that was convened by the Secretary General, it makes very clear that the only time R2P allows the use of force against another state, as opposed to sanctions or diplomacy or anything else, the only time R2P allows the use of force is with the authorization of the Security Council. They're very clear that it has to be Security Council authorized to be legitimate R2P. And so that's not what we're talking about here. We're talking about the interventions that take place without Security Council authorization. So R2P and unilateral humanitarian intervention address two very, very different types of phenomena.
Thank you. The next question is, again, I would say correlated to the first question that I put to you, that even if there may not be any justice through a formal court or tribunal, could there be some form of accountability for aggressive acts by the powerful actors? Could there be some sort of symbolic justice? What is your thought on that?
You mean so justice that doesn't involve the ICC?
The question here doesn't say so, but I guess that's what he or she is actually referring to.
Yeah, I mean, yeah, okay. So I mean, I've addressed the ICC. It's a very difficult question. If we're talking about criminal accountability, normally when we're talking about war crimes or genocide or crimes against humanity, we have, what I'm sure you all know is universal jurisdiction, where any state in the world has the right to prosecute an international crime committed extraterritorially, even if it doesn't have any connection to the state doing the prosecution. It's very debated whether universal jurisdiction extends to the crime of aggression. In fact, the special rapporteur who is dealing with universal jurisdiction for the UN says no, there's not actually universal jurisdiction. Even if there was, it's very hard to see states being too active in trying to prosecute the government officials of other states for aggression because of how deeply political the crime of aggression is. When you're prosecuting someone for aggression, you are saying that their state committed an unlawful act, that the state has violated Article 2.4. States don't tend to like being accused of criminal behavior. And with aggression, they don't even have the kind of out that they have with the other crimes. When you're talking about a crime against humanity, the government can at least say, oh, it was a rogue soldier, or it was a rogue government official. It wasn't really our policy to commit the crime against humanity. They can kind of separate themselves from the criminal act. You can't do that with aggression. You can't convict somebody of aggression unless you are condemning the other state's governmental policy that led to an aggressive act. So you might see aggression prosecutions in super powerful states, the same states that are likely to commit the crimes of aggression. But the idea of a state that isn't as strong prosecuting the government official of a much stronger state that has committed the crime of aggression, it's hard to see how that would happen. So if we're ever going to see prosecutions of aggression, and I'm not just talking about humanitarian intervention here, if we're ever going to see prosecutions of the crime of aggression, it will almost certainly just be at the ICC, for better or for worse.
Thank you, Professor Heller, for that answer. The next question is, I guess in a way you answered it, but
still let me raise this to you again. Could end ever justify means when it comes to UHI?
Sorry, say it one more time.
Could end ever justify the means when it comes to the UHI?
Can you ever justify it? That's your question?
Could the ends justify the means? That, okay, this was our noble goal, so
well, it depends what you mean by the question. If you're asking, could it ever be lawful to engage in a unilateral humanitarian intervention, I would say no. There is no way to avoid violating the law with these. Could we imagine a humanitarian intervention that, despite being technically unlawful, is in fact the kind of intervention that we approve of so much that we don't prosecute it, or we don't condemn the state that is doing it because we understand that they did the right thing? That's possible. Again, I'm very skeptical that we will ever see the perfect unilateral humanitarian intervention, but my answer would be to that: it's still unlawful, but it doesn't necessarily need to be condemned by the international community. But this is my larger point. At the very end of my article, I talk about the ticking time bomb scenario and the prohibition of torture. You know, as I'm sure you know, the prohibition of torture is one of the few absolute prohibitions in international law. You cannot torture for any reason, no justifications, no excuses. It doesn't matter why you're doing it. It violates international law. A lot of people then come around and say, oh, but what about the ticking time bomb scenario? What if the only way to stop a bomb going off and killing 1,000 innocent people is to torture a terrorist? Doesn't that scenario indicate that we should not have an absolute ban on torture? David Lubin, the great Georgetown legal philosopher, has a wonderfully incisive critique of the ticking time bomb argument. And what he's basically saying is, you're using an almost unimaginable scenario, a scenario that will almost certainly never truly exist, to weaken one of the only absolute prohibitions in international law. Why would we weaken the prohibition of torture, given how often torture is used for bad reasons, to try to leave open the possibility of not criminalizing one scenario that is almost certainly never going to happen in any of our lifetimes? I find that compelling. And I think it's the same logic here, that for every one genuinely humanitarian, genuinely successful unilateral intervention, you're going to have 100 that are either pretextual or damaging to the people on the ground. So why would we want to weaken the crime of aggression and open the door to the 100 misuses of use of force in order to leave open a space for the one type of intervention that we probably will never actually see? So that's why I say it needs to be deemed unlawful. And then if we really buy it, we can just avoid prosecuting people, or we could avoid condemning the state that engages in it. That's a better solution to me.
Thank you. The next question is, given the divisive nature of international politics, particularly the Security Council, how do you see genuinely persecuted people to have any protection for persecution which is taking place in their territory? What is the avenue for them?
Well, it's an excellent question. And this is precisely why Harold Coe accused me of being objectively pro-slaughter. Like, oh, you just want to leave the Syrian civilians to their fates, which is not true. I'm just skeptical of whether a humanitarian intervention without Security Council approval would actually make a difference on the ground. But it's a really important point, because we all have to acknowledge that the legitimate type of humanitarian intervention, the intervention that is conducted with the Security Council's approval, is a deeply political phenomenon. Obviously, the only kinds of humanitarian interventions that will be authorized by the Security Council are the ones that none of the P5 object to. You know, it's very, Libya was a very unusual case. Most people thought that the intervention that the Security Council authorized, that the resolution would be vetoed by Russia or China, who are traditionally opposed to these kinds of intervention. For various reasons, Russia and China didn't. veto the resolution authorizing the use of force in Libya. And I think it's quite safe to say that Russia and China felt deeply burned by NATO's intervention, that they, instead of protecting civilians, NATO is much more interested in getting rid of Gaddafi. And now, because of NATO's kind of taking advantage of its mandate, now Russia and China are not going to authorize any unilateral interventions or humanitarian interventions. They're not going to authorize it in Syria. They're not going to authorize it in Sri Lanka. They're not going to authorize it in Yemen because they feel burned by the West. So the Security Council is broken. I mean, we all have to acknowledge that the Security Council is broken. So there is a decent amount of really interesting writing on whether the UN General Assembly could authorize a humanitarian intervention in a situation that really desperately needed international intervention in the form of the use of force. There is something from the 60s called the Uniting for Peace resolution that kind of leaves very vague whether the General Assembly could do this. Sadly, I think the legal argument is probably stronger on the side that the General Assembly can't authorize the use of force in the way the Security Council can. But that legal issue aside, at least normatively or ethically, I'm much more comfortable with that. If the UN General Assembly, as a truly representative body, agreed by, say, a 2/3 majority to authorize states to use force for humanitarian purposes, I would be quite comfortable with that. Might be skeptical that it would work, but at least in terms of the authorization, I think we'd be on pretty firm grounds there. So I think the international community that is concerned with stopping atrocity needs to think more about these kinds of more representative and legitimate ways of authorizing intervention as opposed to relying on the broken Security Council. The other aspect really worth mentioning here is regional arrangements. So I didn't talk about it because it gets very confusing, but the African Union, the Charter of the African Union or the Constitutive Act of the African Union does allow the African Union to intervene militarily in members of the African Union if in fact there's massive human rights violations or there's an unconstitutional change of government. Legally, I don't think this is particularly problematic because it's based on consent. States sign up to the Constitutive Act and they essentially give the African Union advance consent to intervene in their territory if they do really, really bad things. I find that perfectly legitimate. Again, we might question whether the AU will always use its power wisely, but at least that's a much better solution than a superpower deciding unilaterally to use force on the territory of another state in the global south. That's an African solution for African problems based on the consent of African countries. That seems to me to be very legitimate in a way similar to the General Assembly would be in terms of authorizing these things. So those are the avenues that we need to think about trying to multiply if we really want to allow force to be part of the international kind of repertoire for dealing with atrocity.
Thank you. The next question actually links this to your observation right now. It asks, do you suggest any radical reform of the UN Charter to make this Uniting for Peace resolution more practicable, more attainable?
Well, so there's a serious answer and kind of a facile answer. The serious answer is, of course, that we would love to be able to reform the UN Charter in a lot of ways. It's essentially unreformable because any significant reform would require the authorization of the Security Council, which means that the same superpowers that are the problem have a veto over any kind of reform that might take it on. They don't even want to, they're never going to give up their veto. They don't even seem particularly keen on the idea of expanding the permanent veto. There have been talks about, like the BRICS getting a permanent veto, India, maybe Brazil, each giving one. I don't think that's going to happen because the P5 likes being the only 5 countries in the world that can essentially stop the international community from doing anything that they don't approve of. I've often joked that essentially with 194 members of the UN, that the 189 states that don't have a permanent veto should all resign immediately from the UN and then create UN version 2 that doesn't have a permanent veto for the Security Council. And then let the 5 countries that still have their veto kind of have their own 5-person UN. That's also not going to happen. But it's a way of bringing home the fact that the only reason the UN exists was because of the permanent veto being given to the 5 major powers. And unfortunately, the cost of creating the UN was creating an institutional architecture that is essentially impervious to any kind of significant reform. So all we can really hope for is that states, particularly states in the global south, become increasingly assertive at the General Assembly and trying to demand better treatment than they have traditionally been given by the Security Council. I'm not overwhelmingly optimistic that that will happen, but I mean, certainly over the past 40 or 50 years, you have seen legal reform being brought about by the great mass of states that don't have permanent vetoes in the Security Council, and they need to do more of that. There's a lot more states in the global south than in the global north. So that gives you a little bit of an added, a little bit of an advantage.
Thank you.
At least in the assembly.
The next question is, could more Kosovo-like situations give rise to a new customary norm which might eventually mean that unilateral humanitarian intervention is lawful? Maybe the question is asking about acquiescence.
Yeah, no, it's a very good question, and the answer in theory is absolutely. I mean, custom is not static. If there is sufficient state practice in opinio juris, then there can be the emergence of a new customary norm. But we need more than just Kosovo, because again, in Kosovo, that is not a precedent for a customary exception. There was only a couple of states that said, we're acting for humanitarian reasons, and we think that this is establishing a new norm allowing this. Most states didn't say that, even the ones that participated in the Kosovo operation. And again, 133 states said, no, this is unlawful. So what you need is, you need an intervention where the states that are intervening explicitly plant their flag and say, we are trying to establish a customary exception to the prohibition of the use of force that allows unilateral humanitarian intervention. And then you have to have all the other states in the world faced with that very clear-cut claim, not opposing it, really genuinely acquiescing to that claim. If you had that kind of intervention, or you had a few of those kinds of interventions, then we could plausibly argue that there is a new customary exception. But what I've tried to show in the article is that we are so far away from the world in which it's even plausible to argue that there's enough state practice in opinio juris in favor of a customary exception, precisely because all of the examples of the use of force that are often said to support humanitarian intervention don't really support it once you're careful about your legal categories.
Thank you. We are almost running out of time, so this would be the last question that I would put to you. It asks that what to do with a situation like the Rohingyas in Myanmar or the current national unity government, how to respond to that type of a situation by external forces?
I mean, to some extent, your guess is as good as mine. I mean, this is the tragedy of international law, right? I mean, there is no question. There are a lot of situations in the world in which there is massive suffering caused by a government against people subject to its jurisdiction that we would like to do something about. Obviously, Myanmar is a phenomenal example. We can think of the Uyghur in China. We can think of the people in Yemen. We can think of Tamils in Sri Lanka. I mean, we could multiply the awful situations endlessly. And we want to do something for them. And again, I understand the temptation to try to loosen our legal categories to allow them to be helped. But I guess that's part of my argument, that you're not really helping them by relaxing the prohibition of the use of force, that you're going to create far more damage in the long run than any good that you're going to do, because states are not particularly interested, at least the powerful ones, in genuinely intervening to protect civilians. We need, in other words, to kind of stop thinking that international law is going to come and save us, because international law is not going to come and save us. It's not that international law doesn't do anything. It's not that international law isn't capable of doing good things, but international law is very much a product of its kind of its history. It's very much subject to asymmetries of power between states. And it's not a surprise that international law tends to be biased in favor of the great powers. Again, it doesn't mean you can't use it for progressive ends, but we should be skeptical that international law is our primary response to violence instead of one very tiny little piece of the puzzle. We need activism, we need diplomacy, we need smart politics. That's the only way that progressive change comes about. I'm writing a book on the Vietnam War and international law with my friend Sam Moyne at Yale. And you look at the Vietnam War was a terrible, terrible war. The US was completely in the wrong during the Vietnam War. The Vietnam War was not ended by international lawyers. It was not ended by people claiming that there were war crimes and crimes against humanity being committed, although there were, and there were those voices. It was ended by the mass-based political opposition that was created by the Vietnam War. It was the hippies, it was the disillusioned intellectuals in the United States. It was the outrage in Copenhagen and in Stockholm and in countries all over the world in response to the American invasion of Vietnam. That's what ultimately brought about the end of the war. We need to be focusing on peace and not on the use of military force for smarter purposes, because it's almost an oxymoron. Military force is almost never used for truly in the name of peace. So that's what I will leave you with. Don't look to international law as your first resort to deal with mass atrocity. Make it part of the answer, but never forget that there are far more ways to bring about progressive change than to invoke a legal category like the UN Charter or something like that.
Thank you, Professor Heller, for your time and for a very provocative presentation, I would say, thoughtful one as well.
I am nothing if not provocative.
So thank you once again. And dear audience, thank you for your time. We look forward to your company in our next year's webinars. Thank you all.
Thank you very much for your attendance and your attention. It was a pleasure to be here. Thanks, Rizwan. I'm sure you and I will talk again soon.
Hopefully we'll do that very soon. Thank you.
Bye all.